Hello, my name is Jim Toot, and I'm an Associate Professor of Political Science here at Central Virginia Community College. In this video, we will discuss the First Amendment. Freedom of religion. The Constitution and the First Amendment address three provisions regarding freedom of religion. That no religious test shall ever be required as a qualification to any office of public trust under the United States. Article 6, Section 3 of the Constitution. Congress shall make no law respecting an establishment of religion, also known as the Establishment Clause, or prohibiting the free exercise thereof, the Free Exercise Clause. The Establishment Clause. The Establishment Clause is the provision of the First Amendment that prohibits the government from recognizing an official religion. In Engel v. Vitale, 1962, the Supreme Court ruled 6-1 that the Establishment Clause of the First Amendment prohibited non-denominational prayers in school. In Lemon v. Kurtzman, 1971, the Supreme Court ruled 8-1 that a Pennsylvania law allowing the superintendent of public schools to reimburse private schools for the salaries of teachers who taught from public textbooks and with public instructional materials violated the Establishment Clause of the First Amendment. The justices in this case established what became known as the Lemon Test. First, the statute must have a secular legislative purpose. Second, its principal or primary effect must be one that neither advances nor inhibits religion. Finally, the statute must not foster an excessive government entanglement with religion. Outside of schools, the court has been more willing to allow religious practices in official settings. The court has placed some limits on official observances of religious holidays, not permitting any implication or endorsement of a religion. Problems occur when the application of law is counter to a religious tenet, as in the Amish and compulsory education. When actions based on religious belief run afoul of criminal law, the latter prevails, as in the American Indian Church's use of peyote. Many cases signify no interfering with the free exercise of religion. Sherbert v. Verner, 1963, was a case in which the Supreme Court held that the Free Exercise Clause of the First Amendment required that the government demonstrate both a compelling interest and that the law in question be narrowly tailored before denying unemployment compensation to someone who was fired because her job requirements substantially conflicted with her religion. In 1990, in Employment Division of Oregon v. Smith, the Supreme Court held that the state could deny unemployment benefits to a person fired for violating a state prohibition on the use of peyote, even though the use of the drug was part of a religious practice, as it was a neutral law applied in a neutral way. The Supreme Court has held that debate on public issues should be uninhibited, robust, and wide open. Offensive speech is less detrimental than the chilling effect of individuals being silenced for fear of retribution. Nevertheless, freedom of speech is not absolute. Governments can regulate or restrict it under certain conditions. Gag order. Typically a legal order by a court or government restricting information or comment from being made public or passed on to any unauthorized third party. Gag orders are sometimes used in an attempt to assure a fair trial by preventing prejudicial pretrial publicity, although their use for this purpose is controversial since they are a potentially unconstitutional prior restraint that can lead to the press using less reliable sources such as off-the-record statements and second or third-hand accounts. In a similar manner, a gag law may limit freedom of the press by instituting censorship or restricting access to information. Fighting words were first defined by the Supreme Court in Chaplinsky v. New Hampshire in 1942. Fighting words are words which, by their very utterance, inflict injury or tend to incite an immediate breach of the peace. Examples of free speech suppression include the Sedition Act of 1798 and instances during the Civil War, World War I, and the Red Scare that followed. In the 1920s, the Supreme Court allowed the government to bar fighting words as long as there was a clear and present danger of provoking an immediate attack or acts of violence. And in Justice Oliver Wendell Holmes' terms, freedom of speech does not extend to the right to falsely yell fire in a crowded theater. The Sedition Act of 1798 made it a crime to unlawfully conspire to oppose any measure of the government of the United States. To write, print, utter, or publish, or cause it to be done, or assist in it, any false, scandalous, and malicious writing against the government of the United States, or either House of Congress, or the President, with the intent to defame, or bring either into contempt or disrepute, or to excite against either the hatred of the people of the United States, or to stir up sedition, or to excite unlawful combinations against the government, or to resist it, or to aid or encourage hostile designs of foreign nations. Free speech suppression during the Civil War. The Civil War witnessed a similar assault on press freedoms and civil liberty. President Abraham Lincoln seized the telegraph lines, suspended habeas corpus, and issued an order prohibiting the printing of war news about military movements without approval. People were arrested for wearing Confederate buttons and for singing Confederate songs. Government officials shut down the Chicago Times for excessively criticizing the Lincoln administration. Editors were arrested, papers closed, and correspondents were banned from the fields of battle. A military governor, with the approval of Secretary of War Edwin Stanton, destroyed the office of the Washington, D.C. newspaper, the Sunday Chronicle. Prominent Democratic politician Clement L. Vallandigham was arrested for making an anti-war political speech at a party rally in Mount Vernon, Ohio. After his conviction by a military tribunal, he was sentenced to prison. However, President Lincoln changed the punishment to banishment to the Confederate States. Several congressmen attempted to expel Ohio Representative Alexander Long from Congress for an unpatriotic speech made on the House floor. Free speech suppression during World War I. The Sedition Act of 1918 was an act of the United States Congress that extended the Espionage Act of 1917 to cover a broader range of offenses, notably speech and the expression of opinion that cast the government or the war effort in a negative light or interfered with the sale of government bonds. The Sedition Act of 1918 stated that people or countries cannot say negative things about the government or the war. It forbade the use of disloyal, profane, scurrilous, or abusive language about the United States government, its flag, or its armed forces, or that caused others to view the American government or its institutions with contempt. Those convicted under the Act generally received sentences of imprisonment for 5 to 20 years. The Act also allowed the Postmaster General to refuse to deliver mail that met those same standards for punishable speech or opinion. It applied only to times when the United States was in war. The United States was in a declared state of war at the time of passage, involved in the conflict at the time referred to as the Great War, but generally later referred to as the First World War. It was repealed on December 13, 1920. Free speech suppression during World War II and Korea. Before the start of World War II, Congress passed the country's first peacetime sedition law, called the Alien Registration Act of 1940. Title I of this law was called the Smith Act, after its sponsor, Representative Howard W. Smith of Virginia. The law prohibited advocating or teaching the propriety of overthrowing or destroying any government in the United States by force or violence, and the printing or publishing of any material advocating or teaching the violent overthrow of the country. The Smith Act. The act was used to harass and punish members of the Communist Party. In its 1951 decision, Dennis versus the United States, the Supreme Court upheld the conviction of 12 people for Communist Party activity. The court wrote, "To those who would paralyze our country in the face of impending threat by encasing it in a semantic straitjacket, we must reply that all concepts are relative." Free speech suppression during Vietnam. In 1965, the Georgia legislature refused to allow civil rights activist Julian Bond to take his elected seat in the State House because he made comments critical of the war effort. In 1968, demonstrators at the Democratic National Convention in Chicago were met with heavy police opposition. And in 1970, there were the Kent State shootings. During an anti-war protest, National Guardsmen fired 67 rounds over a period of 13 seconds, killing 4 students and wounding 9 others. 1971, the Pentagon Papers. The government sought to prohibit the New York Times and the Washington Post from publishing a series of articles about some highly classified documents about the U.S. government and the Vietnam War. Attorney General John Mitchell sought injunctions to prohibit the newspapers from publishing such information. The case eventually reached the U.S. Supreme Court, which in 1971 ruled 6-3 in favor of the press. In his opinion, Justice Hugo Black wrote, "Only a free and unrestrained press can effectively expose deception in government, and paramount among the responsibilities of a free press is the duty to prevent any part of the government from deceiving the people and sending them off to distant lands to die of foreign fevers and foreign shot and shell." Every several years, in response to national security events such as 9/11 or the WikiLeaks disclosure, legislation is introduced by Congress to criminalize the release of certain materials to or by the press. As a result of concerns over free speech suppression, however, these efforts generally fail. The First Amendment does not protect speech that fails to contribute to the exchange of ideas that is crucial in a democracy, for instance, obscenity, libel, and fighting words. But such forms of speech are narrowly defined. The Supreme Court regards obscenity as unprotected speech, so the challenge is to define obscenity. Miller v. California, 1973, was a landmark decision by the United States Supreme Court, wherein the court redefined its definition of obscenity from that of utterly without socially redeeming value to that which lacks serious literary, artistic, political, or scientific value. It is now referred to as the three-prong standard, or the Miller test, with the third prong being informally known as the SLAPS test. Miller v. California, 1973. Facts of the case. After conducting a mass mailing campaign to advertise the sale of adult material, Miller was convicted of violating a California statute prohibiting the distribution of obscene material. Some unwilling recipients of Miller's brochures complained to the police, initiating the legal proceedings. The question for the court to consider was, is the sale and distribution of obscene materials by mail protected under the First Amendment's freedom of speech guarantee? In a 5-4 decision, the court held that obscene materials did not enjoy First Amendment protection. The court modified the test for obscenity established in Roth v. the United States and Memoirs v. Massachusetts, holding that the basic guidelines for the trier of fact must be A, whether the average person, applying contemporary community standards, would find that the work taken as a whole appeals to the prurient interest, that is, having or encouraging an excessive interest in sexual matters. B, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law, and C, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. The court rejected the utterly without redeeming social value test of the Memoirs decision. Libel. Libel is a defamatory publication unprotected by the First Amendment. To win a libel suit, public figures must demonstrate actual malice revealed by a reckless disregard for the truth. Written falsehoods are known as libel. Spoken falsehoods are known as slander. New York Times versus Sullivan, 1964. Facts of the case. This case concerns a full-page ad in the New York Times which alleged that the arrest of the Reverend Martin Luther King Jr. for perjury in Alabama was part of a campaign to destroy King's efforts to integrate public facilities and encourage blacks to vote. L.B. Sullivan, the Montgomery City Commissioner, filed a libel action against the newspaper and 4 black ministers who were listed as endorsers of the ad, claiming that the allegations against the Montgomery police defamed him personally. Under Alabama law, Sullivan did not have to prove that he had been harmed, and a defense claiming that the ad was truthful was unavailable since the ad contained factual errors. Sullivan won a $500,000 judgment. The question for the court was, did Alabama's libel law, by not requiring Sullivan to prove that an advertisement personally harmed him and dismissing the same as untruthful due to factual errors, unconstitutionally infringe on the First Amendment's freedom of speech and freedom of press protections? The court unanimously held that the First Amendment protects the publication of all statements, even false ones, about the conduct of public officials, except when the statements are made with actual malice, with knowledge that they are false, or in reckless disregard of their truth or falsity. Under this new standard, Sullivan's case collapsed. Prior restraint is a practice forbidden by the First Amendment whereby the government can prevent publication. The government is rarely able to stop material from being published. Even the Sedition Act of 1798, discussed previously in this chapter, did not include this prior restraint. The Supreme Court extended the bans to the states in 1931 when it struck down a Minnesota law allowing the state to suppress a malicious, scandalous, and defamatory publication as a public nuisance, in this case, an abusively anti-Semitic periodical. Prior restraint is rarely justified. In 1971, the court refused to issue an injunction sought by the executive branch against the New York Times and Washington Post on the grounds of violations of national security. In the absence of the government's proof that the national interest would be harmed, the court allowed the publication of the Pentagon Papers, a leaked classified set of documents revealing decisions leading to the Vietnam War. Symbolic speech. Virginia v. Black, 2003, was a First Amendment case decided in the Supreme Court of the United States. 3 defendants were convicted in 2 separate cases of violating a Virginia statute against cross-burning. In this case, the court struck down that statute to the extent that it considered cross-burning as prima facie evidence of intent to intimidate. Such a provision, the court argued, blurred the distinction between prescribable threats of intimidation and the Ku Klux Klan's protected messages of shared ideology. However, cross-burning can be a criminal offense if the intent to intimidate is proven. In the next video, we'll discuss the Second Amendment, the right to keep and bear arms.